I'm bringing this specifically to the attention that even though there are Indian laws, Civil Procedure Code under Order 39 provides for injunctions. However, with regard to inventory proceedings, these provisions have been specifically saved and there are decisions to this effect. This has been confirmed with decision of the High Court as reported in GLT 1991, page 174, and also in the decision reported in AIR 1984, Bombay, page 295. In the latter decision, it was held that Article 904 of the Portuguese Civil Procedure Code dealing with auctions, licitations, in inventory proceedings would apply and was therefore to be deemed in force. In the decision as reported in GLT 1990, volume 1, page 174, it was held that Article 90 and others of the Civil Procedure Code, Portuguese, when I'm referring to Civil Procedure Code here, I'm referring to the Portuguese Civil Procedure Code, would govern executions in inventory proceedings. These examples have been given in order to bring to the fore that any legislation that is sought to be enacted has to necessarily encompass all the laws and provisions of the Civil Code and of the Civil Procedure Code which are still in force in Goa. The Goa Succession Special Notaries and Inventory Proceedings Bill 2008 seeks to deal only with the aspect of succession and of the inventory proceeding, whilst excluding important provisions and amendments subsequently made which deal with marriage, divorce, guardianship, etc., which, being an integral part of the family laws, require that all these laws, being intrinsically connected, should also find a place within any law that is sought to be enacted in Goa. That the existing law, which is mostly in the Portuguese language, requires to be reenacted in its English version is an irrefutable proposition. What is, however, under question is the piecemeal manner in which it is sought to be done, as well as the lack of discussion involved in the process of its enactment. Such an important piece of legislation requires that the government give it wide publicity and that the same be publicly debated, and that after such debate, the material could therefore be discussed threadbare by persons knowledgeable in the law so that we can have the best that is available. It is not possible within the limited time available to me today to have a highly comprehensive critique of the bill. However, some points which I feel are important have been noted here and are going to be read. Any person reading the bill with attention will notice that there are different words being used in the bill in different parts of it to describe the same concept, thus indicating that different people were involved in the translation without first standardizing the terms to be employed in English corresponding to the term appearing in its Portuguese version. Some examples of this, for instance, and I'm referring to different terminology being employed. At such date, if you have the bill with you, unfortunately, it was, I think, not possible you will see that at section 8 of the bill, we have the expression opening of succession. Whilst in section 10.2, the words opening of the inheritance is mentioned. Now both of these are the same, employed in the same context. Yet you have opening of succession in one and opening of the inheritance in the other. Again, the expression estate lever has been used in section 2F. However, in many places where the word estate should have been used, the word inheritance has been employed. As the word estate lever itself explains, it is someone who leaves an estate. So if you start employing the word estate, keep it fixed. Use the word estate throughout. Do not mix it with inheritance, and do not mix it again and again, interchange it. Laws of drafting do demand that you be consistent. The word estate should have been used, the word inheritance has been implied. And Section 6 defined the definition of inheritance. This section corresponds to Article 1737 of the Civil Code. However, this definition starts with the words inheritance or succession of a deceased person comprises of all the properties, rights and obligations. You will note here, there are two things. Inheritance and succession is not one and the same. Number two, we are suddenly confronted with the word deceased person, whilst earlier we were using the word estate leaver. You will note that here the drafter has used the words inheritance and succession as interchangeable terms. This is bound to create confusion. Again, the word properties employed here is misplaced, as the correct term should have been assets, which has been defined in Section 2b and should have been employed in this definition. The words assets as defined in the said section states, assets means properties, movable or immovable, corporeal, whether animate or inanimate, or incorporeal, unless repugnant to the context and includes liabilities. It will be seen, therefore, that the term properties is already an intrinsic part of the definition of the expression assets, which in the Portuguese language is bens. The following suggested definition should cure it is submitted this patent errors. Instead of the word inheritance, it is suggested that the more appropriate term would be estate. Hence, the proposed definition could read as follows. Estate means and includes all the assets, rights and obligations of the estate leaver, which are not merely of a personal nature and which have neither been excluded by the estate leaver nor by law. As this conforms with the definition given in Article 1737 of the Civil Code. As stated earlier, inheritance and succession is not one and the same thing and cannot be classed as synonymous. A reference to the definition of succession is found in Section 3 of the Bill, and a reading of such a section will immediately show the error.
The majority of the people who are present here and in this whole Goa are not aware exactly what are the Portuguese laws in Portugal because there is no translation available. Now, after the translation is given to the common man by the government, the only common man thereafter can give their suggestions for suitable changes. And that is why our demand is that the government should undergo this exercise first before any attempt is made to change this law.
Just attention and also pass on the message outside. There is one situation here. Our afternoon session will be in the seminar hall in the other wing, that is on the southern side, because there is another function to take place here around 4:30, and the organizers of that function are waiting out to decorate the stage. So we'll just try and hurry up. At the same time, the food also is late, but I have instructed the caterer not to start the service before the end of this session. So there is a person whose marriages are not registered in Goa, but they are domiciled of Goa. How they can seek divorce in Goan courts is a subject matter. Shivaji Desai, the person with one good job our Honorable Chairman of Law Commission has done today is solve our problem by asking all inquiries to be referred to Law Commission. I fully appreciate that. But anyway, this is subject matter for legal advice. But a person whose marriages are not registered in Goa but they are domiciled of Goa, how they can seek divorce in Goan courts?
They can seek divorce in Goan courts, but the law applicable will be the law, their own personal law. It will not be governed by the law of the force of Goa.
In any case, we'll try to skip things that are not relevant to the topic, just because this was the first one we allowed it. Godfrey Gonçalves, what is the main difference between the Notarial Act under Portuguese regime and Notarial Act 1952 in India? I think I will ask the President of Notaries.
I am explaining this in short.
Short.
Notaries Act 1952, which has been extended to Goa, encompasses all the functions which are presently being done by the ex-officio notaries. Now, whether this function should be given to the notaries or not is a matter now left to the people to decide from their experience in the past.
Advocate Leo Mendes, does definition 2R or N of the bill provide a backdoor entry for the state to, please, from Advocate Mendes, does definition 2N of the bill provide a backdoor entry for the state to formulate rules as laws pertaining to the law pertaining to marriage, which is not addressed in the bill?
I don't follow the question exactly.
No, he says section 2N, whether it's a
matrimonial regime. You're talking about referring to matrimonial regime.
He says the marriage is not dealt with there, so whether this gives a backdoor entry to formulate rules as laws pertaining to the law.
I still don't follow the question.
Can you say it? Pick up that mic. Okay, please, your voice is loud enough.
While this bill deals only with succession and basically to the manner in which succession can be thereafter excluded or given in transfer of actual inheritance. Surprisingly, this bill does not deal with the family law. A definition of matrimonial regime is entered in. It is not defined, but it provides for making of rules to deal with marriages without having a law comprehensive to the subject, which would provide the legislature by way of rules to introduce as to how marriages can be regulated and governed without a complete law in the subject. This is what my question is.
I think Advocate Mendes, yours is not a question. I think yours is a comment upon the bill. And I agree with you that it should not find a place here.
I agree with you. The next one, I hope this is also not a comment. Will not the applicability of the present bill be larger than the applicability to the remainder of Portuguese Civil Code relating to marriage, family obligations and children, and thus in conflict? Means the bill, the content of the bill, the applicability of the present bill is larger than what will remain in the code, and that it will create a conflict. I think that's what everybody said.
If the bill ultimately is enacted with the ambit that is sought to be created under Section 1, then yes, its ambit would increase. But ultimately, I feel that there is need for a debate upon this particular aspect and how exactly to formulate this Section 1. Which is very, very important. I think a debate is necessary as far as Goa is concerned.
How many adjournments are allowed in the bill? Goa Succession Special Notaries in Advocate W. D'Souza. I have not understood this question. Are you talking in terms of the fees or adjournments in the bill?
There is no question of this. This is a question which does not pertain to the subject matter.
As per the bill, Article 21, inventory proceedings cannot be instituted after 30 years from the date of death of the estate leaver. What if the estate is in the name of a great-grandparent who died many years ago? What is the remedy provided? Advocate D'Souza. In short, I guess
I will answer this question because it has troubled me also. You see, in the civil code at the moment, we do have, there is a prescription which will operate in the same way as you can have a claim of adverse possession and you can deny the right of other co-heirs of a right over the property. You can say, no, I'm sorry, I've been in the enjoyment of this property for more than 12 years, and therefore I do not recognize your claims. For that you would have to go in a civil suit and get and prove through evidence that actually you have ousted the possession of the other co-heirs. But my problem, as far as the limitation period appearing in this bill is concerned, it does not stipulate that the prescription or in terms that the limitation period in terms of 30 years is applicable vis-a-vis anybody. It merely states that you cannot file an inventory proceeding after 30 years. Now my question is, what happens after that? There is no claim of adverse possession by anyone. So the answer could be, you can go in for a succession deed and you can get a partition deed executed. But I have a further doubt in my mind. And the further doubt in my mind is this, that many a time, because of the divergence in names, you cannot have a succession deed executed. Now, if you do not have a succession deed executed, you do not have a proper title. Because you have to understand, the inventory proceeding and succession deed and partition can be, sometimes you can resort to either one method or you can resort to the other. So if you have agreement amongst the parties, you can go in directly for a succession certificate, provided you do not have divergences in the names, and then go in for a partition deed, register it, and that is a good title. When you cannot resort to these steps, either because there is enmity or unfriendliness or disagreement amongst the various co-heirs, then you are bound to go into the inventory proceeding. Once you go into the inventory proceedings, you do not require a succession certificate. The partition deed may be necessary if there are common properties which are claimed by several and have been allotted in that manner in the inventory proceeding. But when you are unable to file an inventory proceedings after 30 years, what is the result of the parties? Do the properties remain without any title? So, this limitation of 30 years requires to be coupled with something else. Either an adverse possession or the way, the manner in which it is framed. I'm sorry, I don't think it's going to help us.
As I've said,
Mike, be there.
I'd like to thank the faculty. Sorry, thank 1 minute. 1 minute. Before this, there is an announcement. I didn't get one.
Mike.
Your name is not written on anyone. Which is this? When it states like Indian contract, what is that? Transfer the property. No, anyway, what is the question you are talking about? Can we have it after lunch, because now the problem is... People are moved once they start. 1 minute, Sadhaka. You are part of our group only. Just bear with me. We also make an announcement.
I'm very short it is. See, when the Supreme Court was elected in the year...
I'm addressing myself especially to the lawyers to communicate to you that after about 4 long years of quite a bit of struggle, the Bar Council of Maharashtra and Goa, a sub-office, is going to be opened in Goa. And we will be having an inauguration of this office. It is located in the 4th building at Panjim in the High Court complex. We will be having an inauguration and all the advocates will be invited for this. However, in case for any reason the invitation should not reach you, I am making it clear here today to all of you who are present, and with the hope that we will also pass it on to our colleagues who are not here present today, that every single advocate is invited, and because it's going to be your office, and we hope that you will come. The date will be announced, and it will come also in the papers. Thank you.
Alright, so I wish to thank the faculty, Mr. Lobo, as well as the moderator, Mr. Karmali, and as token of our appreciation, I would just like to present Mr. Karmali. Mr. Karmali has worked very hard for the success of this seminar. I thank him in many ways. And to Mr. Atul Lobo, who has been a part of it. Thank you very much. Please remember, after lunch, and one thing, your lunch has to be outside. Don't ever dream of getting inside this hall. After lunch, we shift to the seminar hall in the next building. I am pointing the direction because south, north, east, west may be confusing. This is the south. Yeah. So this side. Alright? And we will assemble there at 3:30. Actually,